Thank you.
Welcome. Greetings, everybody, and welcome to the National Constitution Center. It is wonderful to see such a large crowd. I am Jeffrey Rosen. I am the president of this wonderful institution. The National Constitution Center, as those of you know who have been here frequently realize, is the only institution in America chartered by Congress to disseminate information about the U.S. Constitution on a nonpartisan basis. Yay, absolutely. Let's have an applause for that inspiring and unique mandate.
But I don't have to be nonpartisan, do I?
Oh, no, just you present one side and I'll present the other. Absolutely. We're going to have a great discussion today. To achieve this great nonpartisan mandate, we have 3 missions. We're the Museum of We the People, and starting in October, we're going to be displaying one of the 12 original copies of the Bill of Rights. We are a Center for Civic Education, and today we are fulfilling our function as America's Town Hall, the one place in the country that brings all sides of the table to discuss the constitutional issues in the news and lets you, we the people of the United States, make up your own minds. We've had an incredible range of town hall programs in the past couple weeks and months. Last week we had Alan Dershowitz debate Noah Feldman from Harvard Law School about whether the president has the constitutional power to target and kill American citizens abroad. And before the debate, the audience voted no, and after a rousing closing argument by Alan Dershowitz, there was a switch and the audience voted yes. Yesterday, we had an incredible discussion about a wonderful new book about privacy by Julia Angwin. Next week, we have a debate about the Foreign Intelligence Surveillance Court with Judge John Robertson, who resigned from that court out of protest. In the spring, you'll see on the web Justice John Paul Stevens, Lynn Cheney, just an incredible range of people every day and every week here at the NCC. What was that? Oh, sorry. No,
not John Roberts. Robert's son.
Robert's son.
Different judge.
That's an important distinction. Yes. Chief Justice Roberts is still choosing the judges for the FISA court, and John Robertson resigned. That's my way of saying that out of all our town hall programs, there's none recently that has attracted so much attention as the appearance by my old friend and colleague, Jeffrey Toobin. Jeffrey Toobin, as you know, is the most well-known and distinguished legal journalist of our time. You've read him in The New Yorker. You've seen him on CNN. He is the author of not only best-selling but superbly astute and insightful books, beginning with his wonderful book on the Simpson trial, which is absolutely the best thing ever written on the case, to his recent definitive books on the Supreme Court, both the 9 and his recent one about the relationship between Chief Justice Roberts and President Obama. And out of the many relevant and compelling articles he's written, I think one that's attracted some of the most attention appeared in The New Yorker on December 9th. Our broken Constitution, everyone agrees government isn't working, are the founders to blame? So I can't imagine a better location or topic for our conversation. Please welcome Jeff Toobin. We are going to have a friend.
I've known Jeff Rosen since before he was in charge of the Constitution. So that's a long time. And anyway, so it's great to be here. It's great to be back. And my dad was a Philly guy.
Really?
So yeah, I spent a lot of time here. He grew up. He's like Overbrook High School, Temple, and
Nice.
When I was a little kid,
Nice.
I mustard on pretzels. I got the whole program. And my grandmother lived at 1924 JFK Boulevard, as you say.
Yeah.
And I used to go. It was like my big thing by myself. I would walk from there to the Franklin Institute and back, and I was like, it was very exciting.
That is
so
beautiful.
Anyway, I'm like a,
that was as good as the Dershowitz speech. I think
yeah,
you just won over.
I think you just won over the audience. I know how to work.
Right,
you know.
Nice job.
Anyway.
Well, here's what I thought we would do. This is not a debate. This is a friendly Charlie Rose-style conversation. But Jeff does pose a very important question, namely, everyone agrees the Constitution isn't working. Are the founders to blame? In other words, is our dysfunctional government because of the constitutional structure the founders set up, or in spite of it? And what I want to do, just for fun, is to take a vote before the discussion, and then we'll take another vote after, and we'll see how people do. So the question, ladies and gentlemen, is let's posit that our government is broken. Do you believe that it's because of the Constitution or not? Everyone who believes that our broken, dysfunctional government is a result of the Constitution the founders set up, please raise their hand. And everyone who thinks our government is broken for reasons that are not because of the Constitution, please raise their hand. All right. Well, I think you can do it, though. You can bring the crowd around.
It's tough.
It's going to be tough, but
it's an uphill battle.
But it is. If anyone can do it, you can. Well, give us, in a nutshell, the opening argument for why it's the Constitution's fault.
Well, let's just start with the idea that it's supposed to be a democracy, which means rule of the people, and roughly the idea that everybody is equal, that everybody should have an equal say in forming and conducting the work of the government. And then let's talk about the United States Senate, because let's just be specific and concrete. There are 39 million people who live in California. There are 550,000 people who live in Wyoming. They both have the same number of senators. That is ridiculous. That is undemocratic and wrong, and it is, and we can explain why that happened. Everybody knows about the Connecticut Compromise, which is, I was just reading about it as I was walking around the display cases, that in order to get a unanimous vote of the states at the Constitutional Convention just down the block, the big states had to give something up to the small states, and they came up with the Connecticut Compromise, where the big, you had one house of the legislature that is based on proportional representation, and the other that is just two people a state. Now, that's why it happened, but that doesn't mean it was a good idea. And I think part of the dysfunction, and this is just one easy to cite example, is the undemocratic nature of the Senate.
Excellent. Okay, well put on the table. Now, I want to come back in a moment to the claim that everyone agrees the problem that the Constitution is not democratic enough, because many on the right say the problem is that it's too democratic and should be more constrained. But just on the Senate, let's dig into the details. You say the Senate has blocked the League of Nations and the healthcare reform, the Clinton healthcare reform. Wouldn't the argument on the other side be it stopped some of the crazy excesses of the House today? It prevented House Republicans from repealing Obamacare. It was responsible for the budget compromise. Whatever sanity there is in Washington is actually because of the Senate, not in spite of it?
Well, my argument, overstated and ridiculous as it is not that everything the Senate has ever done is wrong. It is really just, it is more of a structural argument that in a system where you want the government to work and be responsive to the will of the people, the idea of having an unrepresentative body like the Senate is wrong. Now, the larger idea behind the Senate is that you will have one deliberative body that takes its time, not as responsive to the immediate whims of the people, and the famous metaphor that George Washington supposedly said, although probably didn't, that it's the cooling saucer, that you pour tea into the saucer to cool for a while, and that the Senate was the cooling saucer, whereas the House was the impassioned, immediately responsive branch of government. You could have a system like that while still maintaining a more democratic idea. The classic difference between the two is the length of terms. You have the House, which is every 2 years. You have the Senate, which is every 6 years. You could have a body that was every 6 years, which would be by necessity somewhat more insulated, but still have a more democratic representation. So it is not that a bicameral legislature, in my view, is inherently undemocratic. It's just that this one happens to be.
Just to press the point on the Senate, you have some very compelling evidence that a big problem is partisan gerrymandering.
Right.
And the numbers on Pennsylvania are especially amazing. You say that the number of the support that Democrats get in Pennsylvania is wildly disproportionate to the number of seats they get because of partisan gerrymandering. What about the claim the problem with Congress is partisan gerrymandering has made the House much more polarized? Half of the Senate comes from the House, and therefore the polarization from the Senate is a result of partisan gerrymandering, not the Constitution.
Well, we have an abundance of problems. And so I would not ascribe the problems of government to one thing, but you've hit on a couple. And if we could just pause for a minute on the issue of partisan gerrymandering, because this is another one of my boring and bizarre obsessions, because and there is no better place to speak of it than Pennsylvania, because Pennsylvania is among the worst offenders. And the most important Supreme Court case that no one's ever heard of also came from Pennsylvania, which is Veith v. Dubelier, which is, I believe, 2006, which was the case that really, where the Supreme Court had a chance to limit partisan gerrymandering and didn't do it, in a 5-4 decision. And if we could just pause to talk about for a minute about what partisan gerrymandering is, because ever since the Warren Court, it's been quite clear, and I think appropriate, that we have a system of one man, one vote, and each congressional district has to have the same number of people in it. And that's why after the census every 10 years we change how many representatives are in each state. But the Constitution says nothing really about how the state legislatures should design those districts. In fact, you don't even have to have districts. You could have a system where you simply, in every state, you rank the number of people, which is sort of a proportional representation system, where you rank 20 people and the first 15 are the members of Congress. I mean, there are, we often think we have the only voting system in the world. We don't. But I mean, okay, you could have districts by design of members of Congress. And so what has happened, ever since computers came into wide use, basically around 1980, you have state legislatures crafting districts so that they are either very Democratic or very Republican. And the perniciousness of this is not immediately obvious, but I think is really profound, because what that means is that instead of having to appeal to broad cross-sections of the country, members of the House of Representatives really only have to appeal to members of their own party. And in fact, most of them have a great deal more to fear from primaries than they do from general elections. And that leads to very conservative Republicans and very liberal Democrats in the House, and relatively few people in the middle. And I think that's a real... And what the Supreme Court said in this Veith case was, you know what, the Constitution doesn't say anything about how you draw districts. As long as they have the same number of people, we're not going to get involved. And I think that was a terrible mistake, and that's the root of a lot of the problems in the House.
Very well summed up, and I agree with all of that. Wouldn't the counter be the Supreme Court was wrong not to regulate partisan gerrymandering? Some have argued that in Pennsylvania, when a majority of voters of the state lack the ability to elect a majority of representatives, that's a violation of the Republican form of government clause. The Supreme Court could have held that. Then the Constitution would have fixed the problem rather than solved it.
Absolutely. No, I mean, we can have an interesting discussion about whether, the Constitution is what we say it is or what the Supreme Court says it is. I don't know, this is shocking to you, but I sometimes think they make the wrong decisions.
No, don't say it.
I know you always agree. But
I suspected this, but I never actually thought of it.
So, no, I think Veith was an awful decision. I think it was terrible because, what you have in effect is, instead of voters choosing members of Congress, you have state legislators choosing their voters. Choosing who is in what district on purely partisan grounds, and that is, I think you could say it's a violation of the Republican form of government. It's a violation of the First Amendment. It's a violation of equal protection. I just think it's wrong, but it was one of those places where the conservatives embrace the concept of judicial restraint, which is a concept they like, except when they don't like it.
But just broadly, again, putting the case on the other side, the Constitution structures this conversation. There are good arguments on both sides, and the fact that both the left and the right can make their arguments in constitutional terms, the Supreme Court isn't always going to get it right, suggests that the Constitution is the one thing that works. And you have in the piece a bunch of quotes from people on the left and the right saying the system is broken, but it's actually not the Constitution. Al Franken, the Constitution has lasted a long time. It's done pretty well. Mark Levin saying that it was really the founders set a good system into play and we messed it up.
The piece starts with Barack Obama and Ted Cruz saying nearly the identical thing about the Constitution. Now, as I believe you know, Barack Obama and Ted Cruz don't agree on a lot in terms of policy, but what they say is, well, the Constitution's perfect. We've just, that's a given. The Constitution is perfect. And why I wrote the piece was, look, there is a measure of overstatement in what I'm saying. I'm not a politician. I don't have to measure very carefully, everything I say. Maybe it'll be a gaffe. Although I am well aware that journalists can get fired for anything they say when there's the camera on. But the point is, we tend to sort of have this automatic lip service we pay to the Constitution. Well, of course the Constitution's perfect. And the whole idea behind the piece is it's not perfect, is that there are structural problems that go back to the framing, and that's worth noting and paying attention to.
I think it's a great thesis, which is why I'm so glad we're having this conversation. But again, just to press, isn't this a conversation that's been going on since the framing? This is the conversation between the Federalists and the Anti-Federalists. The Federalists want to empower government to solve national problems. The Anti-Federalists want to limit it to protect states' rights and individual rights. The Anti-Federalists claiming that an out-of-control central government is threatening liberty, and the Federalists making the opposite argument. Again, the conversation goes back to the beginning, and it's a strength of the Constitution, not a weakness of it.
Well, yes. One of the I was just before I came here. I was going around the exhibits, and there's the great line that's on the wall there from McCulloch versus Maryland, where Chief Justice Marshall says, I'm going to garble it a little, but we have to remember it is a constitution we are interpreting. It's not a statute. It's not a law. It states broad principles that we have to apply in our lifetime, all of which means we know we're going to disagree about it. So yes, it is. So yes, it is true that a lot of these arguments are embedded in the document itself. The tension between a strong federal government and states' rights and individual rights. That's not. That was there was a settlement of some of those issues in the Constitution itself, but they didn't settle all those issues. And so you're right that the Constitution tries to give you a framework, but it certainly doesn't settle the conversation.
Let's talk about the Tea Party and the critique from the right. We've talked about the left's critique that the Constitution is not democratic enough. The right says it's too democratic and threatens liberty. And what I thought of, first of all, I love the fact that Tea Party people are walking down the mall waving the Constitution. Whenever people make constitutional arguments, that's a great thing, just like when Occupy Wall Street does it. But I read your account of the Tea Party, and I thought of I looked it up, I don't have this in my mind, the Pennsylvania Minority Report. When the Constitution is proposed, the Pennsylvania delegation says we need a Bill of Rights because the government's going to be too strong and threatens liberty. Here's what they said. It sounds just like the Tea Party. They say, we dissent because the powers vested in Congress by this Constitution must necessarily annihilate the legislative, executive, and judicial power of the several states and produce from their ruins one consolidated government, which from the nature of things will be an iron-handed despotism, as nothing short of the supremacy of despotic sway could connect and govern these United States under one government. Isn't it the same?
No, and I completely agree with you that it's great that the Tea Party has embraced the Constitution as so much of the basis of what they say. Now, as is evident throughout American history, their view of the Constitution is not necessarily the view shared by, say, a majority of the Supreme Court or even a majority of people. I was talking once, not too long ago, to Kate Zernike, who's a reporter for the New York Times, who wrote a book about the Tea Party, and she said, I go to these Tea Party rallies, and all I ever hear about is Wickard v. Philbin, Wickard v. Philbin, and which is not really the most famous Supreme Court case. It's not Brown v. Board of Education.
Tell the audience.
Well, I will. I didn't expect you to know it either, but Wickard v. Philbin was a case from the New Deal, shortly after the New Deal, where the Supreme Court, part of the New Deal, they were going to regulate the price of wheat. And there was someone who was growing wheat, I believe, in either Dayton, Ohio, or Fort Worth, Texas. I can't remember which place it came from. And they didn't grow wheat. They failed to grow wheat. And the federal government said, well, we can regulate the failure to grow wheat as well. And the Supreme Court said, yes, that's okay. And it was basically one of the decisions that defined the Commerce Clause very broadly, and gave the federal government the power to regulate the full national economy. And one of the heart of the Tea Party's critique is the idea that the federal government has expanded beyond the constitutional limits set by the framers, principally in the Commerce Clause. And this, of course, was the heart of the argument against the Affordable Care Act in the Obamacare case. And this is a good argument to have. I think they're wrong. I think Wickard v. Philbin was right. I think Obamacare is constitutional. But, it's great to have that argument in public.
You list very helpfully and interestingly some of the amendments that Tea Party and other supporters have proposed. Mark Levin proposed liberty amendments to term limits on Congress, limit federal spending and taxes, repeal the 17th Amendment. Randy Barnett, the scholar who is the intellectual architect of the challenge to the Affordable Care Act, has a bill of federalism that would eliminate the federal income tax, allow half the states to rescind any federal law, and ratify the court's decision in Citizens United. Is this a sign that the Constitution is broken, or is that healthy constitutional debate?
Well, you know what? This is one area where the democratic critiques, the progressive critiques of the Constitution, one of the things they focus on is how difficult it is to amend the Constitution. Basically, they say, how can you have a democratic Constitution when it takes, three-quarters of the House, three-quarters of the Senate, three-quarters of the states? I mean, you can stop an amendment so easily with so few people. And I know a great mentor of yours is Akhil Amar from Yale Law School.
Absolutely.
And he pointed out to me, who is, I think, somewhat sympathetic to these progressive arguments and is basically a progressive person. He says, look, this is the test of how, whether the amendment process works or not. How many bad constitutional amendments have passed? And the answer to that, as far as I'm concerned, and I think as far as most people are concerned, is one. Prohibition, which was promptly repealed. So I have to say, I think there is a place that the Constitution gets it right, that it should be difficult to amend the Constitution. And a lot of those constitutional amendments that you were talking about, term limit. And by the way, if it were easy to amend the Constitution, one thing we know for sure is that same-sex marriage would be banned today, because it would have passed easily in when it first, in the sort of the early George W. Bush years when it was passing and all. And I think there's an example of the undemocratic nature of the Constitution really works to everyone's benefit.
That's a great point. Now, to take your side, on the other hand, what are examples of amendments that almost everyone agrees should pass that can't? Maybe the repeal of the Electoral College?
Well, the repeal of the Electoral College is one that I'm certainly for, proudly standing with Richard Nixon on that, who was, one of the sort of key people in this piece who I talked to, someone I'm a great fan of, covered a lot over the years, Orrin Hatch, who, I don't share a lot of his political views, but I think it's just he's a great example of what a United States senator should be. He's thoughtful, he's serious, he's trying to make government work, and one of the first things he did when he came to the Senate in 1976 was lead the fight against the abolition of the Electoral College, and he always says, and we've had this argument several times, he says, without the Electoral College, no one would pay any attention to small states. And I always say to him, when was the last time you saw presidential candidates campaign in Utah? They ignore the small states now. So instead, they just ignore all the states except for the 10 swing states. Now, you're lucky you happen to live in one. But, I live in New York. I've never seen a presidential candidate. Nobody in Texas has ever seen a presidential candidate. We have presidential elections in the same, handful of states, and I think it's outrageous, and it has all sorts of pernicious effects. So that, like a lot of things in Washington, the fight against the Electoral College used to be kind of a bipartisan thing. Now it's completely partisan. Democrats are for it, Republicans are against it, and it's going nowhere.
Why doesn't the left make arguments in constitutional terms as vigorously as the right? You see a little bit of on Occupy Wall Street, but not really people fighting for progressive ideals who are waving the Constitution and marching on the Mall. Why is that?
That's an interesting idea. I think when you look at the great sort of progressive success story of the past 10 or 15 years, which is gay rights and same-sex marriage, you waive the Constitution. I mean, I think that argument has frequently been phrased in constitutional terms. One issue which I find particularly compelling, and particularly on constitutional terms, which is almost never talked about at all, much less in constitutional terms, is D.C. statehood. It's like, how can these people be American citizens and they don't have senators and they don't have they have Eleanor Holmes Norton who goes to committee meetings. That's it. I mean, how is that possible in the United States? Now, why is it? Well, why do you think it is? What do 75% of the people in District of Columbia have in common? I think you can all figure it out. But it's outrageous, and it seems to me completely unconstitutional. But it's not an argument that's made in those terms. What do you think?
I was just on a great panel on that very topic with Judge Ken Starr, who's actually an advocate for D.C. statehood for just the reasons that you described, and I think it was just the political reality. Their claim wasn't mostly that it was race, but that the partisan balance would get messed up. And
it would get messed up. It's like Democrats would get 2 new senators. Now, it depends whether you think that's messed up or not, but I mean,
Jamie Raskin, who's the great advocate for D.C. statehood, came up with some ways that it could be done through statute and not constitutional amendment, but everyone probably agreed it wouldn't work, so it'd have to be.
But why? But just the broader question you asked me, which I, as you can tell, basically have no idea is the answer. Why do you think sort of progressives don't phrase their arguments in constitutional terms?
One answer might be, and you hinted it in this excellent piece, that progressives want to use government and conservatives want to constrain government. So you think of all the things on the progressive agenda, the Affordable Care Act, wage equity, education. They basically want to pass acts of Congress to get the government to do things, and the conservatives want to strike it down. Conservatives, as you suggested, used to accuse liberals of trying to reverse their defeats at the ballot box in the courts. Now, on issues ranging from campaign finance to affirmative action to the Affordable Care Act, you have conservatives the moment that the ink is signed on a bill rushing to court to declare it unconstitutional.
Well, and it might be also, I'm just thinking about it now, since here we are at the National Constitution Center, I mean, if you read the Bill of Rights, as you will be able to read the very actual original copy soon, they are almost all phrased in the language of Congress shall make no law, fill in the blanks. Democrats like to make laws. So, I mean, the very idea of limited government, which is associated with the Republican Party, may be more susceptible to an embrace of the Constitution.
I think that makes sense. And what strikes me is that the framers, or at least Madison, straddled this debate. He was neither an advocate of unconstrained federal power or of George Mason-like Tea Party restrictions on power. He wanted a government vigorous and energetic enough to wage war and protect the economy, but constrained enough not to threaten individual rights. And I think what we have lost in this current debate, as you show so well here, is that moderate sense that you want a government with enough power but not too much.
Easier said than done.
Easier said than done. What do you imagine will be the future of these constitutional debates? We're often called on to have a constitutional convention here at the Constitution Center, and I would love to do that. And there are various ways that we could do it and get delegates and maybe put it on PBS. What amendment do you think would pass? We had an experiment recently, propose your own 27th Amendment, and folks wrote in online, and here's what they said, if I can find it. I think the top vote getter, and here the comment section was quite wide. Here we go. The top suggestion was term limits for Congress. The next four are really close in line, about a vote away. The second was general campaign finance reform. The third, eliminating corporate personhood. And the fourth, abolishing the Electoral College. Surprising? And what else might be on the list?
I think equal rights for gay people. Congress shall make no law on the abridging the rights on the basis of sexual orientation. I think that would have a lot. That would have a lot of support. The Equal Rights Amendment for women, which failed in the early 1980s. Interestingly, the Supreme Court more or less imposed the Equal Rights Amendment without the need for a constitutional amendment, and I think they are sort of in the process of doing that in terms of gay rights as well. I think those are all interesting ideas. I think term limits is certainly. I mean, we have a federal term limit for president, but we don't have it for members of Congress. I think that is certainly one that the public supports. I'm not exactly sure how I feel about that. Progressives, ever since the Citizens United decision, have rallied around the idea to a certain extent of the two of them related to their and I have to say, I think the corporate speech one is barking up the wrong tree. It's I work for CNN, I work for the New Yorker. Those are both corporations. When we want access to something, a court proceeding, some government document, we waive the First Amendment. CNN has the right to see. Corporations do have rights. I mean, that is not something new. Anthony Kennedy didn't invent that in Citizens United. I don't think that is a particular problem. It also, in the aftermath of Citizens United, we have not seen a lot of corporations give a lot of money to campaigns. I mean, it is just not that big a problem. The much bigger problem, I think, with Citizens United is the metaphor that money is speech. The idea that giving money to a campaign is an act protected by the First Amendment. That, to me, is a much bigger problem, and that is what has led to sort of the unconstrained giving that's gone on to super PACs and the like. That, I think, would be a more ripe topic for constitutional amendment than corporate citizenship.
How would you frame a constitutional amendment to overturn that part of the Buckley and Vallejo decision?
Very difficult. I mean, Al Franken and Sherrod Brown have one. I wish I had it committed to memory. It's not bad. It's actually not as bad. It's not as difficult as I thought, but it's basically Congress shall have the right to regulate campaigns, something like that. And it ain't going to happen, so...
Now, our friend Larry Lessig from Harvard Law School says...
He's a big Constitutional Convention guy.
He is, and I hope he's going to lead the Constitutional Convention. He's eager to do this, and if we have it, you guys all have to come back and watch. It'll be a great show. But he says even if you had a constitutional amendment to overturn Citizens United, you'd have the Congress you had the day before Citizens United, which was still structurally corrupt because it was dependent for big donations on donors. And therefore, Lessig says the solution is payment reform, public financing of campaigns, not overturning Citizens United.
Yeah, that's true. I have to say, Larry is a friend of both of ours. I guess, everybody has issues that they are most passionate about and most interesting. I guess I am sufficiently cynical and sufficiently aware of American history to think that the idea of draining money from politics is just a forlorn hope, and that when you squeeze the balloon in one place, everything will go that way, and maybe Larry will have a great triumph and they'll have public financing. We actually in New York City, here's an example of sort of the crazy, the difficulties of campaign finance reform. So we have a very good system of public financing, very equitable, very, low contributions are matched. It's very, fair. And if you notice who the mayor was the last 12 years, it was a guy with $30 billion in the bank when he spent $100 million in each campaign to get reelected. Now, that is, of course, absurd, but that was protected by Buckley versus Vallejo, one of these opinions which said that individuals can spend as much as they want on their own campaigns. So I guess, even in a good system like New York, you have these aberrations. It's just not something that I think is ever going to be solved.
We have lots of great questions from the audience. If there are more, by the way, you still have your cards, and Robin, our great town hall director, will collect them. But before I turn to them, just one sort of the big question raised by this wonderful, provocative article: is constitutionalism better than unchecked democracy? I mean, we've just seen this wave of constitution writing in the Middle East, where Egypt is not turning out so well, and it's because of a lack of limits on government authority, not because of them. So really, constitutionalism and democracy are not the same thing. The framers liked constitutionalism, limited government. Isn't that a great achievement of American history rather than something to be criticized?
Well, it certainly is. Justice Ginsburg got in some trouble a few years ago, where I guess it was shortly after the the various springs in the Middle East, and she was in Egypt, and she said, "Well, our Constitution, no one imitates our Constitution anymore. They use better models now." And she does have a point. If you look at some of the newer constitutions, South Africa in particular, there are certain aspects of it that I think are an improvement on ours. But let's not overstate the important. I mean, look, I hope I don't get thrown out of the National Constitution for saying this, but let's not overstate the importance of constitutions. The culture of a country, the history of a country, has a lot more to do with how free a country is than words written on a particular piece of paper. I mean, I don't want to say that the Constitution is not important. Of course it is. But, Egypt, Libya, Lebanon, you can write anything you want on a piece of paper and call it a constitution. They are not going to have the free system that we have. And with all our problems, I think we can all agree we live in a very great country, and it's not because of the Constitution alone. It's because of the whole package of institutions that we have here. So yes, it's true that some constitutions, South Africa's maybe more preferable as a piece of political science, but I'd sure rather live here than there.
I do want to make a plug now for this great interactive we're developing to open at the same time as the Bill of Rights that will allow you to click on any provision of the Bill of Rights, see its historical antecedents, and watch it spread across the world. So you can see the First Amendment influenced the Norwegian Constitution, which turns 200 this year, or the Fourth Amendment was literally cut and pasted into the Japanese Constitution, and you'll be able to see that across the world. And it is something I think we have to be proud of, the exports of
But also, I think we need to be aware that there are wonderful and free countries that have somewhat different systems than ours. One of the principles that I think all of the First Amendment, Congress shall the two religion clauses. You can't establish a religion, and you have to have free exercise of religion. Well, England's a pretty free country as far as I can tell. They have this thing called the Church of England. And there is and in Germany, which is a thriving democracy, in Germany, some of your tax dollars goes to all the different churches and religions because that's how they set up their system. In Canada and in Germany, you can't deny that the Holocaust took place. Here, you can deny the Holocaust all you want. I mean, I prefer our system both in those areas in terms of regulation of speech and in terms of having no state religion, but it's worth recognizing that other systems can have very free societies in different ways.
You do argue very persuasively at the end of the piece, and I think it's actually quite an optimistic note, that the roots of these changes are the same. The preamble to the Constitution says nothing about judges or politicians. It invokes what should be the true and ultimate authority in American government, we the people. And you say that really, ultimately, constitutional values come from the people, not from the document or from judges or from legislators. And unless the people embrace constitutional ideals, they won't be fresh and vibrant, which seems correct.
I agree.
Yes. All right.
I wrote that.
You did.
I do
you
agree.
did. Congratulations for writing it. Let us turn to some questions. How well would the Constitution work if extensive and thorough campaign finance reform were enacted?
Well, I addressed that to a certain extent. I mean, it would work better. I think the system of money in politics is really in a bad place now, and is a lot of people say in forums like this, ask the question, and you tell me what you think, that do you think the courts saw what a disaster Citizens United is going to cut back on it? And I think the answer is precisely the opposite. I think you have 5 justices, important distinction, 5 justices on the current court who really are engaged in a project to deregulate American campaigns. And we have a case this year about that's going to, I think, further deregulate campaigns. So yes, I think campaign finance reform would be a good thing, even though it wouldn't be nirvana, though some people think it is. But I don't think we're going to see anything like a movement in that direction for quite some time.
Do you believe that the current interpretations of the Second Amendment right to bear arms will ever return to the prior interpretation, i.e. maintenance of a militia, will stare decisis serve to keep it intact?
Yeah, well, I mean, speaking of problems in the Constitution, the Second Amendment, putting aside what you think it means, it is an ungrammatical and nearly incomprehensible sentence. I mean, it really is. I mean, it is, if you remember English class, it's a misplaced modifier at the very beginning. And, the militia clause and then the keep and bear arms clause. Justice Scalia was someone we've both written about a great deal. Did not, served on the Supreme Court for many, many years without winning a really big case for his view of the Constitution. I mean, he won some cases, but in terms of doctrinally, well, he finally won a big one in 2008 in the Heller case, where he imposed his version of what the Second Amendment means, that it gives an individual rights to bear arms. I do think that decision was incorrect. I thought Justice Stevens and Justice Breyer's dissents were persuasive. But again, this goes back to we the people. It's very important, I think, particularly for those of us who live in urban areas, to recognize that not everybody sees guns the way people in urban areas see guns. And, it brings to mind James Carville's famous definition of Pennsylvania, which is, Pittsburgh and Philadelphia separated by Alabama. And, the gun control is not popular in much of the country. So, this is a we the people issue. I mean, until we the people have a different attitude about guns, you can talk about the Constitution all you want. That's the bigger factor than anything that's written in the Constitution.
Speaking of we the people, here's a great question. What role do you see for we the people in fixing our broken Constitution? In other words, do you see the people reclaiming their original right to alter or abolish the Constitution as they see fit, or are they simply relegated to voice their displeasure and hope that their constitutionally defined leaders will determine the best fix?
Well, I mean, this goes to a certain extent to the point you were making earlier that, and I have to say, I didn't deal with this much in the piece, and I'm not entirely clear on it, but there is a provision in the Constitution for another constitutional convention where you can sort of start over, or at least, make several changes all at once. So, you can try. But, as I said earlier, I do think it is basically a good thing that it is hard to change the Constitution. But that doesn't mean that, citizens are without power to, affect the course of government. I mean, we are looking forward to an election in 2016 where it is far from unlikely, I think it is, where the people will get to choose between Hillary Clinton and Ted Cruz. That's a real choice, and that's a real chance to influence which way the country goes. And you don't have to tamper with the Constitution at all to do that. So the idea that people are powerless if they can't change the Constitution, I don't think that's right.
What has been the impact of supermajorities? How did supermajorities happen?
Well, this goes to the question of filibusters, which is another one of my pet obsessions. Just start with the obvious. There is nothing in the Constitution about filibusters. A filibuster is a rule of the Senate. It is just a rule. It's not even a law. It's a rule of the United States Senate regarding the need for supermajorities in certain circumstances. And this law has been, it was originally filibusters could go on forever. Then, I think it was in the 1920s, they imposed a 67-vote rule to cut off filibusters. And then in the 1970s, there was a reform to bring it down to 60, where it remains today. In an undemocratic institution to start with, the Senate, as I was saying earlier, the idea that even 40 senators can stop something is really pernicious. And one of the interesting generational things that's going on in the Senate right now is that even within the Democratic Party, there's a considerable split. Sort of the old bulls, the Carl Levins, the Harry Reids, the Dianne Feinsteins, the people who've been there for a long time, are very protective of the filibuster rule, whereas the younger members of the Senate, Jeff Merkley of Oregon, the two Udall brothers, cousins from New Mexico, Tom Udall, and what's the other one's name? Morris. No, Morris was the Mark, right? And Sherrod Brown, Al Franken. They are less worried. What the old bulls say to them, you don't know what it's like to be in the minority. You'll appreciate the filibuster when you're in the minority. And these younger senators are saying, you know what? We don't care. We think we need to make this place more democratic. We want to move away from filibusters. So it's an interesting tension that's going on in the Democratic caucus.
Here's a really hard question that would be tough on a law school exam for both of us, so I'm going to give it to you. Read the Jubileer decision, the partisan gerrymandering decision. I agree the result of gerrymandering has injured democracy. One, where's the constitutional defect? And two, what's the constitutional resolution that would have allowed the court to intercede?
Well, that's a really good question, and you started to address it a little bit in terms of the Republican form of government. I think you could make an equal protection argument that that discrimination on the basis of party is effectively what's going on here with partisan redistricting, and I think that's part of it. And I do think the solution is not hard. Basically, what would happen is what happens in Iowa. Iowa has a system where there is an independent commission that draws the districts, and California now has a similar system where they basically draw them in roughly contiguous areas. There's nowhere, these famous the reason it's called gerrymandering is that Elbridge Gerry, the governor of Massachusetts in the early part of the country, drew a district that looked like a salamander, and so they combined the words. You'd have commissions in each state, and I think that'd be a good system, a fair system, and there is some movement in that direction because the situation is so out of control.
Okay, 2 more questions, and then we're going to take our final vote. Term limits for Supreme Court justices, good idea?
Probably a good idea. Stephen Breyer gets asked this question a lot and at public forums, and he has an interesting answer. He says, I have no problem with term limits, mandatory retirement, as long as you have one condition. He says, as long as the Supreme Court is your last job, that you don't have Supreme Court justices who are angling for another job. There's a very interesting, which I think is an interesting proposal. There's an interesting proposal out there, maybe you know more about it than I do, where basically they would set up a system of staggered terms for the Supreme Court where every president would get two appointments to the Supreme Court, assuming no deaths. And they would serve for 18 terms, and they would be staggered, so every president would get 2 years, two appointments, and his or her appointments would have 18-year terms. Great idea. Really a very good idea. Never going to happen in a million years. So, again, you'd have to amend the Constitution, and at the moment, with Barack Obama appointing Supreme Court justices, Democrats think, this is a pretty good system we have here. And so because you need supermajorities, you're never going to have, because the president's always going to be either a Democrat or Republican, you're just never going to be able to muster that sort of majority, even though, one of the things about the Constitution, again, the sort of dated nature of the Constitution, when the Constitution was written in the late 18th century, people were expected to achieve prominence in their 40s and die in their 50s. That's sort of what happened. And thus Supreme Court terms were supposedly, thought to be 10, 15, maybe 20 years. Now, of course, fortunately we live in a society where people live a lot longer, and that is now a big factor in Supreme Court appointments. Elena Kagan was 50. Her chief competition for that seat, Diane Wood, was 60. That was a big factor in why Kagan got that seat and not Diane Wood. And that presidents always think that way. And that's, again, I think a defect of the Constitution.
The last question sets up our final vote very well. It's an important constitutional question. Do you watch House of Cards? What do you think? And how much of the dysfunction depicted in House of Cards is the fault of the Constitution?
This is, I'm really going to let you all down. My wife just started work in Washington as a Deputy Assistant Secretary of Education. I'm very proud of her work, and but I'm sort of commuting, and I'm spending time in Washington as well as time in New York, and I have been shocked the degree to which she loves House of Cards now that she's actually part of this terrible system. But I haven't watched it. I guess I'm still enough of a New Yorker that I've never even seen it. So I am going to let you down and not. But maybe I'll ask Amy what she thinks is how much of it is the fault of the Constitution. But I haven't seen it.
All right, we'll put her answer.
You want any questions about Mad Men or Breaking Bad or I watch those. Yeah.
How much of the problems in Mad Men were the fault of the Constitution? That drinking.
The drinking. All those
repeal of the
cigarettes.
Prohibition
My
Amendment.
God.
Absolutely, it was absolutely terrible. Ladies and gentlemen, I think we have to have our final vote. Once again, we're positing that the government is broken, and you're voting how many people thinks it is the fault of the Constitution and how many people think it's not. Who believes that our broken government is the fault of the Constitution?
I think
you got at least
2 votes.
3.
Wow,
I think you got 3 votes.
Wow.
Who believes that it's not?
There you go. All right.
Please join me in thanking Jeff Toobin for a great conversation. Nice job.
The Constitution kind of has a home.